Thank you all for joining us today. Sorry that we're getting a little late start. We just had some technical difficulties there. We hope everyone has managed to join both the web and telephone portions of the presentation. In the event that you're not able to join the web portion for any reason, we emailed the PowerPoint to our registered attendees yesterday at 1 o'clock Pacific, 4 o'clock Eastern, so you can follow along with a paper copy of the presentation. Before we get started, I would like to make a few introductions. First, my name is Nancy Campbell. I'm a partner in Snell & Wilmer's Employee Benefits and Executive Compensation Group. I've been in the group close to 21 years. My practice is concentrated on qualified plans and health and welfare plans. I've been helping my clients sort through domestic partner and same-sex spouse benefits for years. Denise Atwood, counsel in our Employee Benefits Group, is also joining us today. Denise has been kind enough to volunteer to monitor questions as they come in. Just so you know, you can hear us, but we can't hear you. We've turned off the chat feature in order to minimize interruptions. If you need to communicate with us, please use the question and answer feature to do so. For example, if you're having trouble hearing me, or if I'm talking too fast, as I sometimes have a tendency to do, please let us know in the question and answer box provided. If you post a question, other attendees will be able to see it. As I mentioned, Denise will be monitoring questions, so if you have any questions, please select Denise in the drop-down box to send your questions to. Occasionally, Denise may jump in with a question, especially if she sees numerous people asking the same question. She will save other questions until the end. If we don't get to your question, we apologize. And finally, before we get started, if anyone has to sign off early, we will be recording the presentation so you may listen to it later. We will be posting the webinar on our homepage at www.swlaw.com, and we will leave it up for approximately 2 weeks. So with that, let's go ahead and jump right in. One of the reasons that I decided to have this seminar today, July 30th, which is almost a month after the Supreme Court cases, was because I was really hopeful that some of the federal agencies might have issued guidance by now on some of the questions that are left open with the cases. When I checked this morning, they still have not done that. So our presentation today is going to just be based on what we currently know. So let's first talk about those Supreme Court cases and what's exactly going on there. First of all, we had the Defense of Marriage Act, which was enacted in 1996. Section 3 of DOMA provides that for the purpose of federal law, marriage means only a legal union between one man and one woman as husband and wife. And under that section of DOMA, spouse only refers to people of the opposite sex. Now, very importantly, DOMA did not invalidate any same-sex marriages where they were legal, but under DOMA, certain federal benefits could only flow to opposite-sex spouses because same-sex spouses were not considered to be married under DOMA. So the DOMA case that went up to the Supreme Court was actually in a state case. It was United States versus Windsor coming out of the Second Circuit. It was a constitutional challenge to Section 3 of DOMA. Edith Windsor and her lifelong partner were in a relationship, I think it was close to 40 years, and they married toward the end of their relationship in Canada, and then they returned to New York where they were residents. And upon Edith Windsor's spouse's death, she was actually then required to pay an additional $363,000 in estate taxes because she wasn't treated as being married. The Second Circuit in that case held that Section 3 was unconstitutional because there wasn't a rational basis for it. In the California Prop 8 case, which is the second case we'll be talking about today, that's Hollingsworth versus Perry. This was a constitutional challenge to California's voter-approved ballot or Prop 8 ballot initiative, which amended the California Constitution to define marriage as being between a man and a woman. Now, a lot of you might recognize that prior to the passage of Prop 8, same-sex marriage was actually permitted in California for a short period of time. And in this case, when it went up to the Ninth Circuit, that court held that Prop 8 was unconstitutional and it violated the Equal Protection Clause of the 14th Amendment because it used a campaign of animosity to rescind a previously granted constitutional right because the folks of California had for a short period of time been allowed to marry. So let's go ahead and move on to the Supreme Court cases. I could spend really an entire hour just talking about the cases and exactly what they discuss, but we just don't have time to do that today. So really, ultimately, what's important is the holdings. And in the DOMA case, that's the Windsor case, in a 5-4 decision, which was delivered by Justice Kennedy, the Supreme Court held that it did, first of all, have the jurisdiction to consider the merits of the case. That was actually at issue in the case. On the substantive issue, it ruled that DOMA was unconstitutional as a deprivation of equal liberty of persons protected under the Due Process Clause of the Fifth Amendment of the United States Constitution. Now, this is a hugely significant case because the terms spouse, marriage, and other related terms appear in more than 1,300 provisions of federal law. And it just has a significant impact on employee benefit plans because many of the provisions which govern those plans, like the Internal Revenue Code and ERISA, are federal law. And so it's a very important case for that reason. The Prop 8 case was decided the same day as the DOMA decision. And this case actually, if it had been decided differently, could have actually had a very, very significant impact. In this case, we have a 5-4 decision delivered by Chief Justice Roberts. In this case, they actually found that they did not have standing to hear the appeal from the Ninth Circuit. And so the case ended up being vacated and remanded. And as a result of the ruling in this case, California started performing same-sex marriages that very same weekend after the case. Now, this case actually could have been very significant. I originally did not think that the Supreme Court was going to grant cert in this case. That means take up the case and hear it. But they did, and if they had actually heard this case and decided differently, they actually could have legalized same-sex marriage throughout the country, much like they did in the 1960s when they issued the Loving versus Virginia decision, in which they held that all bans on interracial marriages were unconstitutional, and that basically had the effect of legalizing interracial marriages across the country. They could have done the same thing here, but they didn't, basically because they found they didn't even have standing to hear the case. So what we're left with after the Prop 8 case is that California is now just one of 13 states, plus the District of Columbia, that recognize same-sex marriage. Now, very importantly, Section 2 of DOMA was not impacted by either of these cases. Under Section 2, states are not required to recognize same-sex marriages performed in other states, so this means that states still seem to have the right to define marriage. Now, I want to talk briefly about some of the mini DOMA statutes that we have. There's a vast majority of states, actually, that have mini DOMA statutes which prevent them from recognizing same-sex marriages. I think we have about 35 states that have mini DOMA statutes on the books. One such state is Ohio, and the reason I just want to mention Ohio is because very quickly after the DOMA decision, the Windsor case, we have a federal judge has now granted a temporary restraining order requiring state officials to recognize unions of same-sex couples who are married in other states but live in Ohio. And in this case, what happened is we have a couple who's been together, a same-sex couple. They've been together for about 20 years. They flew to Maryland on a medically equipped airplane with the sole purpose of getting married in Maryland. They didn't even disembark the airplane, and they returned to Ohio. And the judge in this case cites Windsor, indicating that he thinks that the parties have a substantial likelihood of prevailing at trial, and so he's now issued a temporary restraining order, basically indicating that the death certificate will have to show these couples as being married. This couple is being married when the one gentleman does pass away. Also interesting, Pennsylvania's Attorney General recently announced that she's not going to enforce their mini DOMA statute. So what we've got after all of this, this is what things look like in the United States and Canada right now. You can see the entire country of Canada, they legalized marriage some time ago on a federal basis rather than on a province by province basis. And you can see that we've got a lot of the Eastern Seaboard permits same-sex marriage. We've got it starting down the middle of the country, Iowa and Minnesota, and then now we've got Washington and California where it's legal. I've got New Mexico gray with a question mark because New Mexico is interesting. It's the only state that doesn't really say that same-sex is permitted, but it also doesn't come right out and prohibit it. And then I've also got noted there now the two red states, Ohio and Pennsylvania, that do have mini DOMA statutes on the books, but because of the case in Ohio and now what the Attorney General has said in Pennsylvania, it's really unclear what the effect of those DOMA statutes are. So let's go ahead and move on to the definition of marriage. What we have with the DOMA case, so DOMA actually provided us a uniform definition of marriage for federal purposes, including employee benefit plans. Now with DOMA gone, what we have is a reversion to state law being the controlling law. But what that now leaves open as a question is, what state law do we look to in determining whether or not somebody is married? Do we look to the place of celebration where the marriage was performed? Now, Obama has actually come out and has indicated that this is his preference. And from a plan administration perspective, really, this would help with plan administration. It would help make plan administration uniform, because really, as a plan administrator, all you would have to know is whether somebody was engaged in a marriage that was legal at the time. It doesn't matter where they live now, and as long as they haven't been divorced, you can treat them as married. The other potential is that the federal government might use a state of residence ruling. They might actually say that if you are in a state like Arizona, for example, where I'm located, that does not recognize same-sex marriage, that then you're not going to be treated as married for federal purposes. Now, this could get really complicated for plan administrators, because if you have to look to the state of residence, you could end up with some employees who are in same-sex marriages that you have to recognize for benefits purposes, but other employees who are in same-sex marriages that you actually wouldn't recognize. And you can imagine from a plan administration perspective, that could be very, very difficult to administer. The federal government could also choose the state of celebration standard for some purposes and perhaps the state of residency for other purposes. So we're just going to have to look and see what they end up doing. For purposes of the rest of the presentation, I refer to these individuals as federally recognized same-sex spouses. So whatever definition the federal government comes up with, those are the folks that I'm referring to as federally recognized same-sex spouses. There is some precedent for a place of celebration standard, actually going back to a very old revenue ruling, 5855. The IRS said that common law marriages would be recognized for federal tax purposes so long as they were performed in a state recognizing them, even if the couple moved to a state that does not. And as far as I'm concerned, this is really one of the most analogous situations to same-sex marriage that I can find so far. And I think it'd be very easy for the government to extend that same type of analysis to same-sex marriages. Also interesting, right after the DOMA decision, the OPM came out for the federal employee plans and said it would be recognizing legally married same-sex spouses regardless of where they were residing. So they would be using that place of celebration standard. But note that that's not binding on private pension plans or health plans. It's just an idea, though, of where the federal government might be headed. Another interesting issue is whether the rulings that we've got could somehow also end up impacting domestic partnerships, civil unions, and other similar relationships. Now, technically, as I see it, the DOMA case does not impact these relationships because they are not technically marriage, they are not technically spouses. But there is a letter, it's an IRS letter to H&R Block, which held the Illinois statute created married status for opposite-sex partners. There's an Illinois statute that basically is sort of an everything but married statute. So it says that if you enter into certain relationships, that you're going to be treated as married folks are. And in this letter, the IRS said that would really be treated, those folks would actually be treated as married for purposes of various rules. And so you could see that maybe the federal government could actually come out and say that in those states that have those everything but married laws, perhaps those individuals are also going to be treated as being married. But as of right now, I think that's a bit of a stretch until we get specific guidance on that. We do desperately need guidance on these issues. The president came out right after the DOMA decision and said that we needed the guidance. We were hoping they would issue it quickly. I was really hopeful that by delaying this presentation until today that we might have had some guidance. By now, we still don't. And the IRS has come out and said it's looking at various issues, but we've not been given any type of a timetable yet. So we're just waiting at this point. We do have some legislation that's out. The Respect for Marriage Act was actually reintroduced on June 26th. This is a bill that actually provides that for purposes of federal law, that the government would use a place of celebration standard for both opposite sex and same-sex couples. The idea is that it really doesn't have people flowing in and out of marital status just because they cross a border. This Respect for Marriage Act would also repeal Section 2 of DOMA. And the real benefit of this legislation passing is that it would be a comprehensive fix rather than a piecemeal regulatory fix. It would be a uniform definition that would help plan administrators. But the possibility of this legislation passing is not real great because we have a Senate that's controlled by the Democrats, the House is controlled by Republicans, and so the idea of this getting passed is pretty slim. Let's move on and talk about the effective date of the rulings. Technically, the Windsor ruling took effect July 25th of 2013, and that's because the Supreme Court has a rule that cases take effect 25 days after they're issued. We're not really sure, though, what this means yet. There is a likelihood that some aspect of the case will have a retroactive effect. And what folks as plan administrators need to think about is what happens if I have an employee who comes in and maybe makes a retroactive benefit claim. Think about how you might deal with that. There is, I think, a theory that if you have previously denied a same-sex couple some benefits based on the language of your plan, and you have good discretionary language in your plan that allows the plan administrator to determine benefits, what they are, I think that there's a strong possibility that could be upheld by a court because at the time that the plan administrator made the decision, they were making it based on what the plan said and what the law was at the time it was made. There is also a likelihood that the case will be given a prospective effect. Code Section 7805B grants the IRS very broad authority to administer Supreme Court decisions prospectively, and that's actually what the IRS did following the Hines case in 2004. They issued guidance limiting the retroactive effect of that case. However, it took the IRS almost a year to issue that relief. So people were, for about a year there, didn't really know what the true effect of the Hines decision was going to be. Now I want to go ahead and just move in and talk about the pre- and post-ruling DOMA worlds that we were living in and that we're now living in. Before DOMA was overturned, employers were unable to treat same-sex spouses the same as opposite-sex spouses for many employee benefit purposes. And so even those employers that wanted to give the full array of benefits to same-sex spouses, they legally just could not do that. So as a result, many employers offered very limited same-sex spouse benefits. And the one benefit that we saw extended most often to same-sex spouses, and probably the benefit that was needed the most, was health insurance. That was the most typically offered coverage. Many employee plans also actually were amended to use the DOMA definition to clarify that it was the DOMA definition that was controlling. And the plans that we most often saw this in were the qualified pension plans. Qualified pension plans really, most of the benefits provided under those plans could not be extended to same-sex spouses. And so a lot of employers just went ahead and amended their plans to use the DOMA definition for all purposes, just, again, to make plan administration uniform and as easy as possible. But now that DOMA has been overturned, we really are living in a very different world. Employers are now going to have to decide if they want to give all rights and protections to federally recognized same-sex spouses or do something less. So the way that I look at it now is, now say you have to give about 75% of protections, let's say, to same-sex spouses. You're still going to be left with a subset of things you don't have to give to same-sex spouses. And the question is, do you want to just go ahead and say, if I'm going to give that 75%, I'm just going to go ahead and give the rest as best I can? I think a lot of employers are going to decide it's just a lot easier to give the full array of benefits to same-sex spouses rather than try to carve out the benefits they don't have to give. And this is really, the employers that do that, your lives are going to be easier because it will just provide for much more uniform administration. And if the federal government actually adopts a place of celebration standard At that point, the only real impediment to uniform administration may be state law. For example, the state taxation of some of the benefits may not still be the same as the federal rule would be, but at least for the most part, you could offer uniform benefits. And I should also note that the DOMA case, very interesting. We had a large group of very significant employers filed an amicus brief in that case, indicating that they thought DOMA should be overturned so that they could specifically offer uniform benefits to all of their employees, opposite sex and same sex. Now that DOMA has been overturned, employers will, though, still have some discretion to decide whether to offer those non-mandated benefits to federally recognized spouses. And the best example here is that there still is no federal law that requires employers to offer group health plan coverage to spouses. And that's true even when the large employer penalties kick in 2015. There still will not be a requirement to offer coverage to same-sex spouses. And so that's the type of benefit you have to ask yourself, if I'm not required to provide it, do I want to? If you do decide you don't want to provide those same-sex benefits, the full array I've been talking about, you have to recognize you're not going to be able to use DOMA as a shield anymore. You know, DOMA really previously, because it was on the books, a lot of employers, put it in their plan. They used it as the standard because it really made plan administration much easier and more uniform. People will not be able to cite to DOMA now as being a reason why they don't offer same-sex spouse benefits. So you just have to think about how that could be perceived by employees. Could they really think at this point that you're really being discriminatory by not offering them that full array of benefits? And with that, I want to actually talk a bit about the non-discrimination laws that are out there, just so that people can kind of think about the potential claims somebody could bring if you don't offer the full array. We have Title VII of the Civil Rights Act. I don't think that that's really a significant issue right now because that does not protect sexual orientation or marital status. But, now that DOMA has been overturned, you never know how courts, could they somehow find a way to expand Title VII of the Civil Rights Act. We also have got some other legislation pending. This legislation has been around for about 40 years now. It gets reintroduced every year. The Employment Non-Discrimination Act, it's modeled on the Civil Rights Act, and it would prohibit employment discrimination based on sexual orientation and gender identity. It was reintroduced April 25th, and again, I doubt that this will get passed, but you just never know what could happen. We also have state non-discrimination laws to think about. Many states have laws that prohibit employers from discriminating based on sexual orientation, gender identity, or marital status. Now, I've looked at these laws, and to the extent you have an ERISA-governed plan, those laws are likely preempted by ERISA, which that just means that those laws, as state laws, are not controlling and not binding on those ERISA plans. But the problem is that ERISA preemption can be hard to predict. You just don't know what a court is going to do. So, and even if you do win in court, you still have the negative press of defending a lawsuit where you deny some same-sex spouse benefits. So it just may not be worth taking that position. For those of us in Phoenix, we also have got a Phoenix ordinance that passed recently that prohibits various types of discrimination. And this actually, interesting, is it's set up as a criminal statute. So again, if you're in Phoenix as an employer, do you really want to be arguing about whether or not this law applies to you? Again, I think that there's an argument that this is preempted by ERISA, but I just don't know if that's an argument that people want to have to try to make. Let's now turn to domestic partner benefits. As I mentioned earlier, the ruling itself really doesn't have an impact on domestic partner benefits because those folks are not spouses. But now that DOMA has been overturned and we've got the federal government recognizing at least the marriages where folks are still living in states that recognize them, employers might want to reconsider whether domestic partner benefits are really necessary anymore. Now, I think for most of us, we're really probably not at the tipping point of getting rid of domestic partner benefits. But for example, if you're an employer and you're located in California and all of your employees are in California and they can all go out and get married, you might say, in order to provide benefits to people, I want to go ahead and require people get married. So depending on your circumstance, Some employers out there might actually think about getting rid of domestic partner benefits. But keep in mind that there might be some other reasons to provide domestic partner benefits. For example, a lot of us have started providing those benefits to senior citizens because senior citizens don't like to get married and give up their surviving spouse benefits. Once you get married, you forego those benefits. And so a lot of senior citizens don't want to remarry, and so people have started to recognize that domestic partner benefits can help those folks out. Also, keep in mind that your ability to eliminate some domestic partner benefits could be subject to state law. For example, if you have an insured health plan, that plan might be required under state law to provide domestic partner benefits. And so if you want to get rid of them, look at those contracts, as I have noted here. Let's talk now about the taxation of health benefits. I've gone on these first few slides here, the tax scheme of health benefits. Essentially, codes 105 and 106 allow preferential treatment for spouses, and that under DOMA did not include same-sex spouses. And the same was true under 125, the cafeteria plan rule, again, favorable coverage for spouses. And these rules also provide favorable treatment for tax dependents as well. The IRS discusses the treatment of domestic partners in various letter rulings. I've got one noted here that explains that same-gender domestic partners are not treated as spouses. So basically, under DOMA, same-sex spouses and also domestic partners were then not treated as spouses and could not get that preferential tax treatment. And according to the IRS, the appropriate measure of the taxation of benefits for domestic partners, which would also be the case for same-sex spouses, is the fair market value of the coverage. Now, under DOMA, the only way that a same-sex spouse or domestic partner could get favorable tax treatment was if they were the employee's dependent under Code Section 152. And in order to do that, they would really have to be a qualifying relative and meet each of the requirements that I've got noted on this slide here. And you can see that there's quite a few requirements. Now, the particularly problematic one is that gross income exemption at the bottom there, that $3,900 limit. A lot of people just could not satisfy that requirement. The good news is, though, we did have some intervening relief. In 2004, we had some legislation that makes an exception to that gross income limit for purposes of 105, and then we had a later notice that did the same thing. So at least for purposes of 105 and 106 of the code, you could ignore that gross income limit and you could still determine that somebody might be a tax dependent there and get the favorable tax treatment. Under DOMA, the domestic partner or same-sex spouse who met all those requirements was treated as a dependent and then could get the favorable treatment. Now, under DOMA, this was really the essence of the tax result. If the employee didn't qualify as a dependent under those complicated rules, the employee would then be taxed on the fair market value of the health coverage provided. They could not pay for their same-sex domestic partner or spouse's share of the premium on a pre-tax basis, and they also could not submit expenses for reimbursement under a health FSA for the domestic partner or same-sex spouse. We also had a complicating factor that various states actually did give favorable tax treatment. So even though these benefits were taxable on the federal level, under some state laws, they weren't subject to taxation. I've got some of the different laws noted there. And so employers, it's very complicated for employers because they had to account for the federal taxation scheme as well as the different taxation scheme across the states. Now that DOMA has been overturned, health benefits provided to those federally recognized same-sex spouses should be provided on the same tax-favored basis as they're provided to opposite-sex spouses. And again, this is going to make benefits so much easier to administer. You're not going to have to worry about the showing of tax dependency anymore. As long as somebody's a federally recognized spouse, they'd be able to get the favorable federal tax treatment. The premiums for those federally recognized spouses can be paid on a pre-tax basis in a cafeteria plan, and then these folks can also request reimbursements for same-sex spouses under these various types of defined contribution arrangement noted in the last bullet. Under DOMA, we also had Social Security and FICA had to also be paid on that imputed income for federal purposes. After DOMA, there will be no FICA or FUTA on the employer-provided coverage. And this is a situation where employers might actually consider requesting a refund for employment taxes they paid on imputed income for the last several years. Now, a lot of employers, if you don't have a lot of domestic partners or same-sex spouses, this may not necessarily be worth going after. But if you have a significant number of those folks, it could be worth requesting a refund. Now, the state taxation of health benefits after DOMA is still a big question mark. Even if the federal government adopts that place of celebration standard, it might not apply at the state level, in which event income would have to be imputed or benefits would still have to be paid for using after-tax dollars on a state level. Some states, such as Arizona, have laws indicating they follow the federal law for tax purposes, but they then have a state constitution or other law, like the mini DOMA statutes, that ban recognition of same-sex marriages. And I have to admit I'm very confused by how these laws work. We've got Arizona that piggybacks off the federal rules, and you would think now would be giving favorable tax treatment to health benefits the same way now that the DOMA rule, the elimination of DOMA does. But we now have the Arizona State Constitution, which says that the state does not recognize same-sex marriages. And so I just don't know how the Attorney General or the Arizona Department of Revenue is going to construe the conflict that we have there. And unless states clarify that issue, it's going to leave employers trying to figure out whether to impute income for state income tax purposes. For those of you that were giving gross-ups to your same-sex couples in order to make them whole and really be providing them benefits on the same basis as you were opposite-sex couples, you can really probably stop doing that to the extent that you now stop imputing income or that you allow them to start doing things on a pre-tax basis. So think about getting rid of those gross-ups. Let's now turn our attention to qualified pension plans. This is actually, I think, the area that really, honestly, is most affected by the DOMA decision. Because of DOMA, qualified pension plans, really just most of the benefits that they provided, they were very limited in their ability to be able to extend all of the benefits to DOMA. And now actually just the reverse is true. These are now the type of plans that are going to have to provide a lot of those same-sex protections or the protections to same-sex spouses. And so I think these are the types of plans that are most impacted by this decision. One of the biggest impacts for defined benefit and money purchase plans are the qualified joint and survivor annuity that's got to be offered when a participant is married. Under DOMA, you could not treat a same-sex couple as being married, and so they would have to be offered the single life annuity. Now, what some of my clients did was they would draft their plans to offer what we called a mirror QJSA benefit. It wasn't a true QJSA benefit, but it was something that came close to a QJSA benefit. And so it offered some protection to spouses, but it really wasn't true spousal protection, because under that scenario, a same-sex, an employee married to a same-sex spouse could go ahead and elect whatever benefit he or she wanted to, regardless of any type of spousal consent. And after DOMA, it's the completely opposite result. Now, same-sex couples will have to be offered the QJSA. Again, it's those federally recognized spouses, and so they will have true spousal protection after DOMA. The qualified pre-retirement survivor annuity, again, this is something that defined benefit and money purchase pension plans have got to provide. And here, you could actually, under DOMA, you really could get something very close to a true QIPSA. So it wasn't quite as difficult to offer the QIPSA to same-sex spouses, but a lot of employers still didn't do it because it wasn't perfect. But after DOMA, you will have to offer that QIPSA benefit to the federally recognized same-sex spouses. And so again, these folks will now have true spousal protection. We also, under the 415B limits, have some effects. To apply those limits, you have to actuarially adjust benefits other than the straight life annuity. But the QJSA benefit doesn't have to be adjusted. And so the value of that benefit is not considered when you apply the Section 415 limits. And because a true QJSA didn't, you couldn't apply it to same-sex spouses, so the mirror QJSA had to be adjusted to a single life annuity for 415B purposes. And so the result of this rule is that we no longer would need the mirror QJSA, and then that benefit would not have to be adjusted. Those folks are going to get the full true QJSA. Rollovers. Under Code Sections 402 and 408, upon a participant's death, the spouse can roll over a lump sum death benefit tax-free to an IRA, but under DOMA, same-sex spouses and domestic partners cannot roll over death benefits tax-free. Now, the Pension Protection Act gave some relief to folks. It does permit non-spouse beneficiaries, including an employee's domestic partner or same-sex spouse, to roll over an inherited retirement benefit directly to an IRA. This would then allow them to stretch the distributions over their lifetime. But the problem here was that this was an optional provision. An employer could have this in their plan and allow employees to do it, but they didn't have to include that rule. If you did want to do this, though, you did specifically have to amend your plan to do it. After DOMA, the federally recognized same-sex spouses will have to be allowed to roll over death benefits to the same extent that the opposite-sex spouses get to. Now, if you do have that PPA protection, though, I would suggest leaving that in your plan because that is still a good provision and it helps out your domestic partners. We also have got some significant changes on the 401A9 side of things. Generally, the pre-retirement death benefits are required to commence within a year of a participant's death or be paid in full within 5 years. But as you can see in the second bullet, surviving spouses can actually defer that until the April 1st of the year that the participant would have turned age 70 and a half. But while DOMA was the law, that rule was not available to same-sex spouses or domestic partners. We also, the minimum payments during a participant's lifetime, the opposite sex spouse beneficiaries would get to use the longer of the uniform table or the joint life expectancy. Same-sex spouses couldn't do this, so the opposite sex spouses were able to take smaller distributions. And then the minimum payments after death, again, the opposite sex spouses got a recalculation rule that the same-sex spouses didn't get the benefit of, and again, opposite sex spouses had to take smaller distributions from their qualified plans. So after DOMA, you now have got the federally recognized spouses are going to be treated the same as the opposite sex spouses. They'll be able to defer benefits until April 1st of the year the participant would have turned 70. They get to use the longer of the uniform table or joint life expectancy, and they also get to use that recalculation rule. So this will result in smaller distributions, which is a favorable tax situation for the same-sex spouses. Hardship distributions, most 401k plans have hardships. It's an optional provision whether or not you do that. If you do, under the safe harbor rules at least, you can make a distribution on account of medical expenses, tuition, et cetera, of an employee's spouse or dependent. And hardship distributions were not available for same-sex spouses unless they were the spouse's tax dependent. Now, the final regulations did actually have a rule in it which essentially allowed the same type of the ability to ignore that gross income limit like we talked in the context of the health plans for 105 and 106. So it was at least a little bit easier being able to ignore that rule that somebody might be a tax dependent and you might be able to take a hardship on their account for those reasons. But again, this was an optional provision. Employers didn't have to do it, but if they did do it, if they wanted to do it, they had to include it in their plan. The Pension Protection Act also allows participants to take hardships incurred by a non-spouse, non-dependent person, and that would actually include same-sex spouses and domestic partners if the person was designated as the participant's beneficiary under the plan. But again, this is an optional provision and plans didn't have to do it. If they wanted to, they had to include it. After DOMA, I think the answer is that plans may, but probably don't have to permit hardship distributions on behalf of federally recognized same-sex spouses. But to the extent you want to, it's going to be a lot easier to give the full array of hardship distributions. You won't have to worry about tax dependency or anything like that. You'll be able to just give them to same-sex spouses as a federally recognized spouse. Note that even if you don't extend the hardship distributions to same-sex spouses, you will now have to take into account the same-sex spouse's assets in determining whether or not a participant qualifies for a hardship distribution. Very important are the beneficiary designations. Most plans have got what we call default beneficiary designations that are used in the event a participant doesn't designate who's going to get his money when he dies. And usually you'll see the order is set as being a spouse, then usually it's followed by children, parents, siblings, etc. And plans could, under DOMA, but we're not required to recognize a participant's spouse as a spouse for that purpose, so they could treat that person as being in that default list. Plans could not, though, require a same-sex spouse to consent to a participant's beneficiary designation in favor of someone else. So if Joe and Sam were married and Joe designated his mother as being his beneficiary, he could do so without Sam consenting to that designation. After DOMA, very different rule. The federally recognized same-sex spouses have got to be treated the same for purposes of those default beneficiary designation provisions, and you will now have to get the consent of a same-sex spouse to beneficiary designations in favor of anyone other than the federally recognized spouse. Now, keep in mind, you want to probably look at some of your prior beneficiary designations. If you've got some same-sex spouses who have actually designated somebody else to be their beneficiary, if they did not get spousal consent, and you probably wouldn't have, those are probably invalid at this point in time. And this is really the same result as if you have a participant who is single, designates mom as the beneficiary, gets married. The second they get married, that beneficiary designation is now invalid because you don't have spousal consent. So now you've got these folks who, under the DOMA ruling, are now considered married. You would need to get spousal consent from them. Now, the real challenge, though, here can be knowing who your same-sex couples are. A lot of people don't really know who their same-sex married employees are, so that can be a challenge. Another problem while DOMA was the law was quadros. Quadros are the way that we divide pension benefits, and they can be issued only in favor of certain people, such as spouses, former spouses, and children. And so under DOMA, these folks were not considered to be married, and so you could not issue a quadro in their favor. The only way you could issue a quadro to a same-sex spouse or domestic partner was if they qualified as a tax dependent, and you would, for that purpose, have to take into account that gross income limit that we got to ignore for some purposes. And it's very unlikely that once a participant and same-sex spouse have divorced that they would ever qualify as a tax dependent. So in most cases, plan administrators could not honor quadros entered in favor of same-sex spouses. We actually had to decline those quadros. But after DOMA, qualified plans will now have to honor quadro in favor of those federally recognized same-sex spouses. This is very helpful for plan administrators because they don't have to worry about paying. If they do pay a same-sex spouse, they don't have to worry that they might have to now pay mom and pay a second benefit because mom challenges the payment to the same-sex spouse. Previously denied quadros in favor, those actually might now spring back and be valid. If you've previously denied a quadro because it was entered in favor of a same-sex spouse, that could actually be valid. And so if you've done that and you remember it, you might want to think about the implications of that. The odd part here, though, is that same-sex spouses could still have trouble getting quadros in states that don't recognize same-sex marriage. For example, if a couple's married in Massachusetts, they now move to Arizona, Arizona doesn't treat them as being married, so it's probably not going to enter a divorce in their favor, nor is it going to enter a quadro in favor of a same-sex spouse. So we still have some problems that same-sex couples can face. We have a whole host of other issues. There's just too much to talk about in an hour. You've got spousal consent for loans, defined benefit plans that offer distribution forms with a Social Security offset. Those might have to be recalculated. The addition of same-sex spouses can impact the funding of defined benefit plans. And we also have got control group issues. Don't forget about that. All of the employee benefits world is done on a control group basis. And so now same-sex spouses are considered married, so any stock that they own is now going to be attributable to each other. And it could have been the case previously that some folks, maybe they didn't have a control group of companies because one spouse owned one company, another spouse owned another company. Those could very now well be considered to be part of a control group. Let's move on to health and welfare plans now. Now, as I said earlier, really, this was the one place where the health benefits, at least, where employers were most often to give same-sex spouse benefits. And as I mentioned also earlier, employers still have discretion whether they want to, I think, give most health and welfare benefits to same-sex spouses. They don't have to give the coverage to spouses, but do note, when the large employer penalties kick in 2015, in order to be considered as offering coverage to any employee under the rule, you also have got to offer coverage to all of their children, including stepchildren. So now, if you don't offer coverage to a same-sex spouse's child, then that could actually have an impact on whether or not you are complying with those large employer penalties when they kick in. So keep that rule in mind. The cafeteria plan mid-year changes, cafeteria plans provide that you can make changes mid-year during if you have certain types of change in status events. And under DOMA, a same-sex marriage or divorce just quite simply didn't qualify because the people were not considered to be, spouses for purposes of the plan. We also had the problem that same-sex spouses, when they died or they had an employment change, that didn't qualify as a change in status event. In some cases, though, you could have a mid-year election if you had a change in the number of dependents. So if you actually got married, for example, and that somehow caused your same-sex spouse to now be a tax dependent, you might be able to make a change under the DOMA rule. After DOMA, plans may, but are probably not required to permit mid-year election changes under 125 plans to the same extent that they do them for opposite-sex spouses. Now, you also have to ask yourself if the Windsor ruling itself wasn't a change in status event. Marriages that previously weren't recognized for this purpose, now it's almost like they sprang into existence and were like a new marriage on that day. The federal government, the plan for employees, they're indicating that people can actually make a mid-year change because of that ruling. They're treating them as new spouses for that purpose. You might also be able to allow mid-year changes for people based on a change in cost or a significant improvement in benefits. For example, there is a tax improvement here, so that might be a reason why somebody might want to add a same-sex spouse to coverage. Dependent care assistance, just kind of quickly after DOMA, the earned income of federally recognized same-sex spouses now counts for the DCAP limit. And after DOMA, an employee will not be able to reimburse a federally recognized same-sex spouse. So if you previously had somebody who was having their same-sex spouse perform daycare, they could actually get reimbursements under a DCAP to do that because they weren't married, and they won't be able to do that now. And after DOMA, the same-sex spouse has also now got to be working, looking for work, or a full-time student or incapable of care in order for the employee to be able to get reimbursements to care for children or others. And then also after DOMA, an employee with federally recognized same-sex spouse will actually now be able to use the DCAP to reimburse expenses associated with the care of the federally recognized spouse, which is a really nice thing for same-sex spouses who are in need of care themselves. COBRA is the bane of all of our existence. It's one of the most difficult things to administer. It's got a huge adverse selection problem, and COBRA basically requires plans when somebody has a qualifying event to offer coverage to qualified beneficiaries, which includes spouses and children. But under DOMA, of course, same-sex spouses were not treated as a spouse, and so they weren't technically entitled to DOMA coverage if they were divorced, et cetera. Now, the IRS had, though, come out and said that if a same-sex spouse lost coverage on account of termination of employment or reduction in hours, that the employee should be able to elect coverage for domestic partners or same-sex spouses if they were covered. But that was informal guidance. There also, though, is the idea that if a participant wasn't offered COBRA for a same-sex spouse, that they would also have to be able to add them at open enrollment during the COBRA period. Now, while DOMA was in effect, I would say most, but not necessarily all, employers offered who offered the same-sex spouse benefits also extended COBRA benefits to those same-sex couples. But some didn't because they just disliked COBRA so much because of the adverse selection issue that if they weren't required to do it, they didn't. And sometimes they also couldn't offer that if their insurance company or stop-loss carrier wouldn't agree to insure that. After DOMA, of course, if you have a federally recognized same-sex spouse who's on your medical plan, you will have to provide COBRA coverage upon the occurrence of a qualifying event, so divorce, employee termination. Also think about if you now have got some same-sex folks who might be entitled to any initial or even COBRA election notices now because they have got to be provided COBRA benefits.
Nancy, we've got a question. I don't know if you want to address this now, but what's the date that an employer should treat as the effective date of a change?
You know, we just really don't know at this point. I think you could probably argue that the date of perhaps the DOMA ruling is maybe when the people were recognized as married. I think we will get guidance, though, on this issue. But what you probably would want to do is amend your cafeteria plan to specifically allow the coverage and, as soon as possible for same-sex spouses. That's probably the best approach. But I do think we'll get guidance from the agencies as to when the marriage basically kind of sprung into existence, if you will.
So employers could probably wait until that guidance comes out.
Well, I don't know that that's the case because the problem with cafeteria plans is you technically can't amend them retroactively. Hopefully when guidance comes out, it might give some type of a retroactive effect and allow us to amend plans retroactively, but we just don't know what the guidance will look like. So it might be safer to amend those now. Under DOMA, we had special enrollment rights. Those didn't really extend to same-sex spouses, although if a dependent was on the plan, a same-sex spouse was on the plan and lost coverage, in that case you did have to give special enrollment rights under HIPAA. After DOMA, you will, of course, have to extend those special enrollment rights to federally recognized spouses the same way that you do for opposite-sex spouses. FMLA allows folks to take leave to care for family members, including spouses and children. And while DOMA was in effect, employers could but didn't have to offer FMLA-type leave to care for same-sex spouses and domestic partners. Under the sort of no good deed goes unpunished rule, though, an employer that did offer that FMLA type of leave, if somebody did take leave to care for a same-sex spouse, it could not count against their 12-week FMLA leave. So if somebody took, say, 6 weeks to care for a same-sex spouse and then had a child or themselves that got sick, they would then be entitled to an additional 12 weeks of FMLA. After DOMA, employees will have to be allowed to take family leave to care for those federally recognized same-sex spouses. That will count against their 12-week entitlement. But I caution you here because FMLA is the one area where regulations specifically look to the state of residence. So they already have a standard built into them. And so even if the federal government adopts that place of celebration standard, it could take longer to change the FMLA regulations. And so if you're in a state where same-sex marriage is not recognized and you do give that type of coverage to your employees, make sure that you still don't count it against their 12-week FMLA leave until we get guidance indicating that you can or should. We have a whole other host of issues here. Again, just no time to talk about them, but think about them again in the health and welfare context. Those control group rules also apply. And then want to talk about executive compensation plans here for the last few minutes. These are very interesting because state law governs these plans. We've got equity comp, non-qualified deferred compensation. These are just contractual arrangements, the terms of which are, for the most part, governed by state law. And therefore, any rights provided to a spouse are going to be determined under state law, but the question is which state law? Is that where the employer is incorporated, where the employee resides, the place of celebration, where the contract specifies that the governing law is? And I think that an argument really can be made that any of these might be the correct answer. But what I would recommend here is to help avoid potential litigation, it's critical that you choose which state law applies and just consider expanding your choice of law provision to make it clear what state law applies, and perhaps even adopt a very specific standard that applies just for determining if a person is in a legal marriage. And here's an example. I've got an employer, they're incorporated in Delaware, but they're operating in Arizona with their employee residing in Arizona. The employee goes to California, is married in California in a valid ceremony, and the employer now grants the employee an equity award, and the person dies without completing a beneficiary designation. The plan has got one of those default beneficiary designation provisions that says the spouse gets the benefit, and so the question is what law do we really look to here? Now, Delaware is important just because so many companies are incorporated in Delaware. And if you have a Delaware choice of law provision, then you could be confined by what's going on there. And I've got that laid out in this slide. Delaware actually now recognizes same-sex marriages. And so if Delaware is the controlling law, then the result could very likely be that you would actually have to then give the benefit to that same-sex surviving spouse. I doubt that in that scenario California law would control because the only relationship is that the employee got married there. But if Arizona law would somehow apply, then the same-sex spouse might not be entitled to the benefit. So again, just think about what you want the result to be and draft plans accordingly.
Nancy, do you have a couple minutes to talk about the impact of Article 4, full faith and credit clause in the Constitution?
Probably not. I probably in the last few minutes here want to get through the action items. Because we just have a few minutes since we got a late start, I apologize. So the action items to think about are really most importantly, to what extent do you want to provide the same-sex spouse benefits? Again, that's we now live in a world where you have to give certain protections now to same-sex spouses. And do you want to give everything, or do you only want to give the things you're required to provide? That's really the first question, those mandated versus non-mandated benefits. I'm really suggesting, and Denise, kind of and I were talking about that earlier when she raised the question, to some extent, take a wait-and-see approach if you can. The good news for a lot of us is that a lot of us don't have same-sex couples, and maybe even if we do, they're not hugely impacted by this decision because some of them might already have their same-sex spouses on our plans as domestic partners. But do what you can now. For example, if you are an employee in a state, an employer in a state, that the state recognizes same-sex marriage, you might stop imputing income now, or allow people to make some of those mid-year changes that we were talking about. You really want to look at all of your plans and policies to determine how spouse and marriage are used. Pull any employee benefit plan off the shelf, and if you just, look at the word, do a search for SPOUS, you'll find so many hits in your plan document. So you need to really call those documents and see exactly what, how the terms are used. And then start thinking about amending your plans to get rid of the DOMA definition of spouse, and especially those qualified plans. A lot of the qualified plans specifically picked up the DOMA definition. Be careful, though. If you did add some protections for same-sex spouses and you now think about getting rid of them in qualified plans, think about whether 411D6 might prevent you from getting rid of, for example, a mirror QJSA benefit. Hopefully the IRS will issue guidance on the amendment deadlines. Will we have to all amend our plans by the end of this year? Not sure, but there probably will be some guidance, and we'll probably have a deadline about when we need to amend those. As I mentioned during that question we got, some plans, such as cafeteria plans, can't be amended retroactively unless the agencies grant relief. So if you want to treat this as a mid-year change for your same-sex spouses, and are comfortable that you can do so because you're in a state, for example, that would give favorable treatment, then you might go ahead and start making some of those amendments now. And then you may sometimes also need two definitions of spouses. If you do decide to provide some protections but not all to spouses, you might have to have two definitions of spouse in your plan. Again, reconsider if domestic partner benefits are still needed. For insured plans, review those insurance contracts. Domestic partner coverage can still be mandated by state law, so you don't want to kind of jump into getting rid of benefits only to find out you still have to provide certain things with your insured plans. And then for self-funded plans, look at those stop-loss insurance policies. Another thing you need to do is update your SPDs and other employee communications. Again, this is really running across all of your plans and SPDs. Revise your COBRA, HIPAA, Quadro, and other handbooks as needed. Amend those payroll and accounting systems to reflect the new tax scheme. And again, be careful here because for a lot of us in different states, we're going to have to still have a federal scheme where maybe there's favorable tax treatment, and in the state, the tax treatment could be different. And, some of you might even start reaching out to your departments of revenue, seeing what their position is on the taxation of these issues. You never know. You might actually get a state to tell you what it is that they've got in mind as far as the taxation scheme for these benefits. I contacted the Arizona Department of Revenue, I think it was about a week before the ruling, and I didn't get a sense that they were really actively working on trying to figure out what the impact would be after DOMA. So I don't know what they've since done after the case. And clearly, just keep an eye out for more guidance. I'm not sure when that's going to come. But really key to all of this is how the federal government is going to define marriage. Are they going to define it as the place of celebration, or are they going to define it as a place of residency? I think we'll all just have to wait and see on that one. So thank you for attending, and again, as a reminder, we will have a recording posted on our website, I think probably within the next day or so. Thank you.